First information report in a criminal case is an extremely vital and valuable piece of evidence for the purpose of corroborating the oral evidence adduced at the trial. The importance of the above report can hardly be overestimated from the standpoint of the accused. The object of insisting upon prompt lodging of the report to the police in respect of commission of an offense is to obtain early information regarding the circumstances in which the crime was committed, the names of the actual culprits and the part played by them, as well as names of eyewitnesses present at the scene of occurrence. Delay in lodging the FIR quite often results in embellishment, which is a creature of afterthought. On account of delay, the report not only gets bereft of the advantage of spontaneity, danger creeps is of the introduction of colored version, exaggerated account or concocted story as a result of deliberation and consultation. It is, therefore, essential that the delay in lodging of the first information report should be satisfactorily explained. Investigation being the formal procedure of discovering of the facts and figures of the crime in hand is essentially important to find out what exactly constituted the crime. Investigation includes search for material and facts in order to find out whether or not an offense has been committed by the accused or not. It includes all the proceedings under the Code of Criminal Procedure within bracket CRPC for the collection of evidence by the police officer or any person who is authorized. It was propounded that in a criminal case, the fate of the proceedings cannot always be left entirely in the hands of the parties, crimes being public wrongs in breach and violation of public rights and duties, which affect the whole community and are harmful to the society in general. That the concept of fair trial entails the triangulation of the interest of the accused, the victim, society, and that the community acts through the state and the prosecuting agency was authoritatively stated. The Honorable Supreme Court observed that the interests of the society are not to be treated completely with disdain and as persona non grata. It was remarked as well that due administration of justice is always viewed as a continuous process, not confined to the determination of a particular case, so much so that a court must cease to be a mute spectator and a mere recording machine but become a participant in the trial, evincing intelligence and active interest, and elicit all relevant materials necessary for reaching the correct conclusion, to find out the truth and administer justice with fairness and impartiality both to the parties and to the community. The observations and the propositions, though made in the backdrop of a request for retrial, those pertaining to the essentially of a fair and complete investigation and trial, as well as the solemn duty of the courts to ensure the discernment of truth, to administer even-handed justice as institutions of trust of public faith and confidence, are in our estimate of universal application and binding effect, transcending the factual settings of a case.